Hi, everyone. Welcome to the 39th Public Interest Environmental Law Conference called PILC. My name is Megan Sweeney, and I'm one of the conference co-directors this year, and I'll be serving as a moderator of this panel. If you are a legal professional and you are trying to get CLE credit, please look into the chat. I'll be dropping a link with a Google Doc that explains the whole CLE accreditation process and what forms you need to fill out, including the JOP form, payment form. And then also, if you would like to donate to our alumni board, the Friends of Land or Water, they help support and raise money for student stipends to fund students who are doing unpaid internships over the summer in the field of environmental law for the public interest. So I will be dropping that link in the chat right now, and I'm going to hand it over to my co-moderator, Kathleen.
Thank you, Megan, and welcome everybody to this panel discussion called Axis of Betrayal, which will be an account of an international human rights tribunal that issued a devastating opinion on fracking and climate change. And it will be an invitation to think with us about the transformative power of the human rights case against fracking and climate change. I'm Kathleen Dean Moore. I'm a moral philosophy professor from Oregon State, and I'm the author or the co-editor of Moral Ground, Great Tide Rising, and now the co-editor of Bearing Witness, the human rights case against fracking and climate change. So for about 10 minutes, I would like to be able to talk with you about the context, set the context for the discussion, citing human rights violations of fracking and climate change, the failure of governments to protect human rights, and efforts to compel government action through international law. And I'll introduce the other panelists as they come on. I think you'll find that they're an extraordinary group of people, and we welcome them. Robin Bronen, Tom Kearns, and Anna Greer. So we begin with this proposition, that with the possible exception of global nuclear war, the climate crisis is the greatest threat to human rights the world has ever seen. The world has, of course, seen starvation and plague and genocide, terrible widespread threats. But the climate crisis is on a different scale of dangerous because it undermines the very systems that sustain the minimal conditions for human life. Already, John Knox, the former UN Special Rapporteur on Human Rights and the Environment, reports that, and I'm quoting him, rising sea levels, increasing temperatures, extreme weather, and changing rainfall patterns are undermining an ever-increasing number of people's and communities' rights to food, water, health, shelter, development, and life. So as I was preparing for this panel, I considered categorizing and documenting the human rights disasters for you. And then I thought, have mercy. I mean, everyone already knows. We have been looking out at the tragic statistics, all the arrows ratcheting off into the future. And we have been looking into the pictures of starving children, but we know, we all have for decades now been staring into the faces of the children. And we know that by causing the climate crisis, fossil fuel extraction is a major driver of human rights violations. And even unmediated by climate change, the methods of extreme extraction themselves directly violate human rights. Fracking, hydraulic fracking in particular, directly harms the health, livelihoods, and neighborhoods of frontline communities, which are primarily the home to poor and people of color. We begin also with this proposition, that governments have failed and are failing spectacularly to protect the rights of the citizens by restraining the oil and gas industries. In the United States, local, state, and federal governments actively encourage fossil fuel development, as you know, through subsidies, tax breaks, sub-market leasing arrangements, and many more steps. And you know that initial steps taken in the 1970s to control environmental destruction through statutes and regulatory agencies began to fail almost immediately, as the agencies became the permit issuing rather than the permit reviewing agencies. Industries captured and now control many of the very agencies that were designed to regulate them. The failure is compounded by how generously governments and politicians share in the wealth that is generated by oil. With the legislative and the executive branches largely failing to restrain the industries that fund them, enrich them, finance their elections, those who would protect human rights from the climate crisis have turned to the courts. Some of them are making cases based on the statutes in their nations. But often, these statutes are written by the oil and gas industries themselves, the very industries that the statutes were intended to regulate. So it's no surprise that many of the human rights violations of the extreme extraction industries are perfectly legal. 70 years ago, the world saw that when human rights violations are legal under the laws of states, as was the case in Nazi Germany, there's a demonstrable need for international law to call nations to account. So the nations of the world came together to sign the Universal Declaration of Human Rights for the first time in history, affirming shared moral standards of human decency and calling on states to protect the universal rights to life, liberty, and security of person. Since then, the international community has expanded the sphere of universal rights with numerous other agreements, including the European Convention on Human Rights and many, many more. So now, in recent years, an increasing number of human rights-based cases are appealing directly to international law. Urgenda versus the State of Netherlands became, in 2019, the first case in which a nation's own court ordered its government to take climate action on grounds that are beyond the mandates of the statutes of that nation. In that case, the court ordered the government to reduce greenhouse gas emissions by 25% of the 1990 levels by 2020, citing, among other things, the European Convention on Human Rights, Articles 2 and 8. Everyone's right to life will be protected by law, Article 2, and so will their rights to respect for private and family life, Article 8. And now, for the first time in history, an international civil society human rights court has weighed the evidence that fracking and the climate crisis are systematically violating human rights. May 14th, 2018, this highly respected Rome-based Permanent People's Tribunal began a week-long hearing on the impacts of fracking and climate change on human rights. And after hearing eyewitness accounts, some of them from Robin, and legal and moral arguments, some of them from Anna, the tribunal ruled that, number one, fracking systematically violates both substantive and procedural human rights. Number two, that in what the court called an axis of betrayal, governments are complicit in the rights violations. And number three, that to protect human rights and the climate, the practice of fracking should be banned worldwide. I submit to you that that case makes history. The court's opinion is a global affirmation that when climate change and the extraction techniques that fuel it directly threaten the rights of human beings to life, liberty, and security of person, then deeply held and broadly accepted moral norms have been violated, including those encoded in the Universal Declaration of Human Rights. So by summoning the power, by relying on the Universal Declaration of Human Rights, the case summons the power of the greatest moral consensus the planet has ever achieved. A rights-based approach highlights the necessary condition between human well-being and environmental thriving. Life is perilous. Liberty is meaningless. And security of person is impossible on a scorched planet whose life support systems are collapsing. On the other hand, the full manifestation of human potential is nurtured by fertile soil and reliable rain and abundant food, stable temperatures, equitably shared. So a rights approach dissolves the human and nature dichotomy that has paralyzed effective collaborations between social justice and environmental movements. And it transforms global warming into a moral and social issue rather than one that is purely environmental, technological, economic. As Pope Francis wrote in Laudato Si, our work is to link social and ecological wrongs, the desperate instability of the poor, and the fragility of the planet. We have to integrate questions of justice in debates on the environment so that we can hear both the cry of the earth and the cry of the poor. A rights approach makes that linkage, as the People's Permanent Tribunal's special session on fracking and climate change made clear. Some members of the group that's here assembled petitioned the tribunal to hear that case. They are here today to discuss its significance in this session. So Tom will tell a story of the tribunal, but first, Robin will offer examples of the testimony presented to the tribunal in order to show the necessity of summoning the moral power of the human rights approach. And Anna will talk with us about what it is about the human rights approach that gives it the potential to change the narrative about climate crisis, and what more needs to change in that narrative. So first, let me introduce Robin Bronen. Robin is the human rights attorney who has, since 2007, been researching and working with communities forced to relocate because of climate change. She has worked with the White House Council on Environmental Quality to implement President Obama's Climate Change Task Force recommendation to address climate displacement, and with the UN High Commissioner for Refugees Climate Change Office. She's a senior research scientist at the University of Alaska, Fairbanks, and the co-founder and the executive director of the Alaska Institute for Justice, a non-governmental organization that's the only immigration legal service provider in Alaska. Robin, thank you for being here.
Thank you so much, Kathleen, for that introduction. So I'm going to share my screen now. Sorry about that. Just need to get back to the beginning. So thank you again for that introduction. And I want to echo some of what Kathleen has shared, in that we have known about the climate crisis for a really long time, and we have continued to not reduce our greenhouse gas emissions at the awful consequence of peoples all over the world who are now contemplating whether or not they can stay in the places they call home and that they love. And in my work as an immigrant rights attorney for many years, I don't think there's any greater human rights challenge than the one that is being caused by climate forced displacement. And so that's the topic of my presentation today. And I always think it's important to ground what is happening in regard to the climate with what's happening in the Arctic, because I'm sure all of you know that the Arctic is warming twice as fast, at least, as the lower latitudes, and it is deeply alarming, the rapidity of change. So I always start my presentations by talking about polar amplification, to understand the gravity of this change in the Arctic. So as you can see from these maps, particularly the one from wintertime in 2018, right? So wintertime in the Arctic is a time when the sun does not rise above the horizon. And despite that, in 2018, there were 61 hours of temperatures above freezing, particularly over Greenland. And then if you go to 2019 and 2020, you will see that that warming trend was not an anomaly, but something that is persisting, where you have increased temperatures as high as 6 degrees Celsius occurring in the wintertime in 2019 and 2020. And it's important to remember that the Paris Agreement, the aspirational hope of not increasing our temperatures above 1.5 degrees Celsius has already happened in the Arctic. So we are in a changed environment in the Arctic, and that has horrific consequences for the peoples who live in the Arctic, but also for the entire planet, because the Arctic is the warming of, provides the cooling mechanism for the entire planet. I always also focus on Arctic sea ice extent, because that to me is the most visible for all of us to see what these high temperatures are doing. So if you look at the slide, you will see that in September of 2020, which is when they normally measure the lowest extent of Arctic sea ice, because we're coming off of the warmth of summer. So in September of 2020, it was the second lowest extent in the 42-year record captured by satellite imagery. And it's one of 14 years of this trend of reducing Arctic sea ice extent. Now that is serious of concern for several reasons. One, from a climate perspective, it means more ocean is open to sunlight, so that the warming is not just now from the air temperature, but it's also coming from the ocean. And the loss of Arctic sea ice has tremendous consequences for the Alaska Native communities that live along the coast. Because in the Arctic sea ice is the natural barrier. Where there are no seawalls, there has been Arctic sea ice. We don't get hurricanes in Alaska, at least not yet, but we get hurricane strength storms. And those hurricane strength storms without that Arctic sea ice is causing ushtek, which is a Yupik word meaning catastrophic land collapse. And it's caused by the combination of erosion, thawing permafrost, and flooding. And it's ushtek that is causing communities along the coast of Alaska to contemplate whether they can continue to remain in the places they call home. So I want to next talk about community relocation, because for several Alaska Native communities, this is what they are needing to contemplate in order to make sure that their lives and livelihoods can continue in the face of a dramatically different Arctic environment. And so the first thing that's important to understand about community relocation, which is a form of climate-forced population displacement, is that it has to be voluntary. And the reason why I say this is because our world has a horrific legacy of government-mandated relocations, where governments have made the decision that people need to be relocated, and people have suffered tremendous harm because of that. In Alaska, that happened during World War II, where the federal government relocated the Unungan people from the Aleutian Islands to Southeast Alaska, and 10% of the population died. But it's also happening now with World Bank funded projects where they are forcibly relocating populations for infrastructure development projects. And the World Bank actually has an involuntary resettlement guidebook to guide national governments about how to resettle populations against their will. And I mention this because the World Bank is now looking at this issue of planned relocation in countries to, in theory, help governments to relocate their populations because of the climate crisis. The second thing that's important to understand about this issue is relocations need to happen while people are still living in the places they call home, because that is the best way that we can protect their human rights. And the most important human right to protect is the right to self-determination. So we talk about this as a disaster risk reduction strategy, so that people are moving out of harm's way, still living in the places they call home, so they have the time to plan their relocation in ways that honors their culture, their traditions, and their right to self-determination. It's a long-term process. It can take anywhere from a minimum of 3 to 5 years. This hasn't happened yet in Alaska. In Alaska, it's actually taking more than 20 years for some of the communities who have made this decision to relocate. And then, of course, human rights have to be protected. So those human rights that Kathy was talking about in regard to the right to food, the right to potable water, all of these human rights must be embedded in any relocation process, with the right to self-determination leading that. And that's to ensure that people's communities, the infrastructure of their communities, and the things that are important to them, their kinship and cultural ties, are maintained in the ways that they want to maintain them. So one of the communities that when I was going back to school to get my PhD in 2007, my research was focused on the community of Newtok. And it is a Yupik community in Southwest Alaska along the Yukon-Kuskokwim Delta. And in 2007, the tribal government, actually before 2007, the tribal government had made the decision in the late 90s, I believe, that the relocation of their community was the best long-term strategy to ensure their community's thriving culture and livelihoods. And they began a relocation process. They identified a relocation site, which is across the Ninglik River, which is the river that you can see in these slides. And their relocation site is about 12 miles away across the river. They made that decision, and Congress authorized a land exchange in 2003. And in 2019, and this is after giant amounts of effort by the tribal government and state and federal government agencies, only 1/3 of the population has been able to get to their relocation site. 2/3 of the community still remain in their current location, which you can see on this slide, which is in horrific danger anytime extreme weather events come, because there's no higher ground, as you can see. No place to evacuate to. All of these communities are only accessible by small plane. And so it is urgent that this community get the resources they need to relocate. So there are 4 giant governance issues that we at the Alaska Institute for Justice have been working on for a really long time. So first of all, in the United States, but this is true for many places in the world, there's no government agency that has the mandate or funding to relocate populations. And this is one of the reasons why Newtok hasn't yet been able to relocate. And there was a US government accountability report issued last year that basically said unclear federal leadership is a giant problem in relationship to community relocations. This 2020 report is the 3rd. So this documentation of the lack of federal leadership is not new. It's time for action. The most critical piece is there's nothing that says who makes this decision. So as I've already mentioned, government mandated relocations are horrible for the populations that have been relocated. And so everything that we are doing at the Alaska Institute for Justice is to make sure that the tribes are making this decision, that the tribes have access to the information they need to make this decision, and then the resources that they need in order to implement what they identify as their best long-term adaptation strategy. The other critical piece to this issue is when. If it's a long-term planning process, which I just said, and it's taken Newtok over 20 years to get to this place, at what point in time does a community need to start thinking that they can no longer stay where they are? And this issue is also one that we are working intensively with the tribes in Alaska on, because there needs to be some identifier to facilitate this process so that the people on the ground can make all of these decisions in regard to how they're going to relocate. And then, of course, how can human rights be protected? And there, again, for us, the answer is the right to self-determination and making sure that the tribes are in making all of these critical decisions. So the challenge at the international level is that there's no human rights document that actually identifies the human rights principles that need to adhere to this process I've just described. The principles exist in a lot of existing human rights documents, but it's not found in one document. And when I do these presentations, people often remind me about the guiding principles on internal displacement, because that's what I'm talking about, is population displacement occurring within countries. That's a really important document, but it doesn't address this issue, because the guiding principles on internal displacement, first of all, they're primarily focused on conflict, people fleeing conflict. But more importantly, they're specifically focused on the natural disasters that occur, like extreme weather events that displace people. And as I've mentioned, people need to be in their current community in order to make sure that their right to self-determination is protected. And the guiding principles on internal displacement, a lot of these things of housing and food are being provided by the humanitarian community within that document. So we need a complete reframing of what human rights need to be and to be implemented in order to make sure that all of these rights that are listed here, the right to subsistence, the right to practice and revitalize cultural traditions, that those are protected before, during, and after the relocation occurs. So again, at the Alaska Institute for Justice, we've been working with 15 tribes now since 2005. And we are developing this governance process with them, which the heart is to decolonize the systems that have caused the communities to be, first of all, located in the places where they are. And then to ensure that federal and state government programs are honoring tribal sovereignty and their right to self-determination. Because the governance systems that currently exist are based on colonial models. They've been imposed on communities, and we are working with the tribes to identify how to reframe these programs so that their tribal sovereignty is respected, promoted, and protected. And then finally, we've been doing work internationally, and one of the critical pieces is to understand that this issue that I've just described is not just happening in Alaska, but happening in many parts of the world. And in 2018, we co-facilitated the first climate forced displacement convening for First Peoples and Indigenous peoples. We were hoping to have our second one last year, but of course the virus prevented that. But it is just absolutely critical when we're thinking about human rights and the consequences of us failing to reduce our greenhouse gas emissions, that we honor the First Nations of this world and make sure that their rights are protected in the face of unprecedented environmental change. Thank you.
Oh, and thank you, Robin. That is a powerful account that you've given and a powerful vision that your group has. Will you tell people how they can connect up with your work? You have a website or some other way they can find out what you're doing?
Sure. So folks can check out our website. It's www.akijp.org and find a lot of materials there about the work that we're doing with the tribes in Alaska.
Thank you. I imagine you'll be getting some hits. Very interesting. Now, Tom Kearns is next, and he's going to talk to us about the Permanent Peoples Tribunal itself, the special session. Tom is a professor of philosophy emeritus at North Seattle College. He's the director of Environment and Human Rights Advisory. In 2015, he and Anna Greer helped draft the International Declaration on Human Rights and Climate Change. Dr. Kearns with Dr. Greer co-organized the International Tribunal on Human Rights, Fracking, and Climate Change, which is the subject of this discussion. He is the co-editor of the forthcoming book, Bearing Witness, The Human Rights Case Against Fracking and Climate Change, and he's the founding director of youthclimatecourts.org. Tom.
Thank you, Kathy. And thank you, Robin. I mean, you laid that out so clearly and cogently and powerfully. And I don't know if we've told you this, but your presentations, your testimony during the tribunal was some of the most powerful of the whole week. So extremely grateful for the important work you're doing. So
Thank you.
yeah. This Permanent People's Tribunal session on human rights, fracking, and climate change was a major group endeavor. Hundreds of people contributed to it, and I wish we could acknowledge them here, but time doesn't allow. The whole thing began shortly after a conference in Oñati, Spain, that Anna had organized in 2012 on human rights and the environment. And a paper at that conference got Anna and I thinking together about how we would petition the PPT to hear a case, the Permanent People's Tribunal, to hear a case on human rights and fracking and climate change. We decided, though, that the first step would be to prepare a human rights impact assessment of fracking in the UK. Would be the best way to start. Two earlier human rights impact assessments of fracking had already been completed. One was, just a second here. Why doesn't this move? One was for New York State, had been completed by Environment and Human Rights Advisory a few years earlier. And a second HRIA was prepared by Mercy Global Action and the Sisters of Mercy in Ireland. And now this third one would be focusing on fracking in the UK. It was commissioned by the Bianca Jagger Human Rights Foundation in London and completed a long process, about a year long, at the end of 2014. And then also in 2014, Anna and I and Damien Short, director of the Human Rights Consortium at the University of London, early in 2014 began the process of petitioning the Permanent People's Tribunal in Rome to conduct a series of hearings on human rights and fracking and climate change. We chose the PPT because it was a long established, juridically competent, highly respected, economically independent and politically independent civil society human rights court. And the two things that you really look for in a court, in any court, are that it be competent and that it be independent. Well, the PPT, with its 40 years of hearing human rights cases, is certainly competent, and it is economically and politically independent as well. It's not beholden to any government or to any economic system. So the court had been founded in the 1970s. It was descended from the International Vietnam War Crimes Tribunal that had been organized and conducted in the late 1960s by philosophers Bertrand Russell and Jean-Paul Sartre. Philosophers like to point to that because it shows that philosophers can actually do things. And in its 40 years of hearing cases, it had developed a substantial body of human rights jurisprudence that it could draw on. So it took a full year before our application was finally accepted. Lots of back and forth. We sent a petition. They had questions about it. We responded to those questions, sent it in again. They had more questions. So it took a whole year. And it was finally approved. The petition was finally approved in early 2015. And then preparations began. Building the website, locating witnesses, engaging with NGOs around the world, finding attorneys to argue the cases, all pro bono. All this is voluntary, nobody's paid. Finding a lead attorney, we ended up with 2 lead attorneys. Searching for funding, fiscal sponsors, identifying potential venues, etc. There are many, I can tell you, many hiccups over the next few years, and a few, 3 I can remember, totally impassable, impenetrable brick walls that we could not see any way through, over, around, under. They were just, and we just despaired. And then somehow a couple of weeks later, we were doing it more. We just kept going, and I don't know how miracles happen, I guess. Until finally, Kathleen comes along and generously introduced this project to the Spring Creek Project at Oregon State University. And they, Carly Latero, director, Shelley Stonebrook, program coordinator, and Emily Grubby, grad student intern, enthusiastically, professionally, and very competently took it all on, training all those judges around the world. And judges, of course, you might expect are of a certain age and not entirely familiar with technology, but they're being, the Spring Creek folks trained all of them in how to use Zoom, because we had all decided in the weeks before this that it would be best to conduct this tribunal fully online if it was possible to do that. We didn't know, nothing like that had been done before. And we did it for 2 reasons. One is because of the horrendous cost that we were facing of for food and travel and lodging for 10 judges and a dozen attorneys and a bunch of witnesses to come and spend a week somewhere. And early on, a couple of us roughed out a potential budget, and it came to about $750,000. So, and we just weren't having any luck raising that kind of money. So that was one reason we decided to go fully online if it were possible. And the second reason was to provide access to people anywhere in the world who would not normally have access to a human rights court. And that is one of the things that the judges, by the end of the week of hearings, appreciated the most. They thought this was revolutionary, that it opened up the human rights courts, civil society courts, to people who would have never had access before. And indeed it did. We had witnesses, judges. These 10 judges were from all over the world, as were the attorneys, a dozen of them, and as were a couple hundred witnesses. So it was a success in that sense. So during the year leading up to the week of hearings in 2018, 4 preliminary tribunals had been organized by local community leaders who had heard about the PPT hearings that would be coming up, and they wanted folks in their communities to be able to testify and present evidence. So the way they did it, all 4 of these places, was to conduct a preliminary tribunal in their community. They were almost all of them were one day, a Saturday. They found a panel of 3 or 4 judges to serve on this tribunal, and then invited people from all around the region to come and testify if they wanted to. And so at each of these preliminary tribunals, one was in Youngstown, Ohio, one was in Athens, Ohio, one was in Charlottesville, Virginia, and one in Brisbane, Australia. 150 or so witnesses came to those total, and stood up before a microphone and in front of cameras and with quavering voices told their stories. And It was really emotional for many. We were told by some of those organizers that these witnesses, after they had testified, were out in the hallway just sobbing because no one had ever listened to them before. And they appreciated just being heard. So in all 4 of those preliminary tribunals, all the witness testimony was video recorded. And then all those video recordings were transcribed. And then each tribunal organizers wrote up a report of the whole tribunal and sent all that material to us. And we provided it to the judges about 3 months before the week of hearings so that they'd have time to go through it. And then, and all that material is available on the website that I'll point you to at the end here. Then during the week of hearings, which was in May of 2018, the 10 PPT judges, and just as an aside, the PPT chose their judges. We didn't have any say in who the judges will be. They were independently chosen, which is significant because many ad hoc tribunals that are put on around the world kind of pick their own judges and pick their own witnesses. And so the results are almost predetermined, but that was not the case here at all. During the week of hearings, the judges watched online, person to person, arguments and testimony from more than a dozen attorneys. They read through 15 amicus curiae briefs, listened to leaders of prominent NGOs around the world, studied 3 UN reports on fracking and climate change. And in the 20 weeks prior to the week of hearings, the Spring Creek Project had organized a lecture series that they called the Bedrock Lecture Series on Human Rights and Climate Change. And they invited 20 thought leaders from around the world. You'd recognize many of them, most of them maybe, to record their own short presentation, had to be less than 20 minutes, and then send that recording to the Spring Creek folks. And they would then, and they did, stream one of those lectures each week in the 20 weeks leading up to the hearings. And all that was submitted as testimony to the poor judges who were, I'm sure, just overwhelmed at the amount of testimony they had to go through. So we had asked the PPT for an advisory opinion rather than for a verdict on a specific situation, you know, in which some government or some corporation had perpetrated such and such a series of actions on a certain location. We didn't want a verdict, a guilty or not guilty verdict about a particular situation, even though that's what the PPT had always done in past cases, because we didn't want its rulings to be applicable only to that situation. We wanted the rulings to be applicable globally. So we asked for an advisory opinion on 4 questions. These 4 questions were laid out in nice legal terms, but what they came down to was, number 1, does fracking violate human rights? Number 2, does government inaction on climate violate human rights? Number 3 was, do fracking and climate change violate rights of nature? And 4th, if so, what does the court recommend? So the week of hearings was in May of 2018, and the court issued its final advisory opinion in April of 2019, 11 months later. So they clearly had put a lot of thought into it. They were working in 3 languages, Italian and English and Spanish. So there was a lot of translating that had to be done also. And so the court's 100+ page advisory opinion was powerful and pointed. Yes, they said, fracking violates both substantive and procedural human rights, including the rights to water, to health, to security of person, to participation in decision-making about environmental matters, and others. Yes, they said, government inaction on climate change violates human rights because governments have an obligation to respect and secure the rights of their citizens. So government failures vis-a-vis the climate crisis undermine the rights to life, to an adequate standard of living, the rights of indigenous peoples to their traditional lands and resources, the rights of women and children, and many others. Yes, they said, both fracking and climate change violate rights of nature standards. Yes, they said, governments are colluding with industry in what they termed, as Kathy reminded us, an axis of betrayal. And the reason they called it betrayal was because governments have an obligation to protect the rights of their citizens, and governments now are betraying their citizens by not meeting their obligation to protect those rights. So here are some recommendations.
Very quickly, Tom, all right? Very quickly.
Pardon?
Very quickly on the recommendations.
Okay. Number one, fracking should be banned globally. Number two, ecocide should be given a similar recognition as genocide in international law. And third, the international human rights regime, the whole system of international human rights, should be integrated with rights of nature in what the court termed a blended jurisprudence of human rights and rights of nature. Now, all that material is available on the PPT website, Tribunal on Fracking.org, all the video recordings, all the testimony. So that's it.
Thank you. So you all have that, www.tribunalonfracking.org. It's also curated and put together in Tom's and my new book called Bearing Witness, the Human Rights Case Against Fracking and Climate Change. Thank you, Tom. And thank you, Tom and Anna, and all your committees for doing all that extraordinary work for the world. Now I'm pleased to introduce Anna Greer. Anna is a professor of law at Cardiff University in the United Kingdom. She studies the relationship between human rights and the environment, calling particularly on insights from critical legal theory and jurisprudence. She's the founder and editor-in-chief of the Journal of Human Rights and the Environment, and until 2017 was also the founding director of the Global Network for the Study of Human Rights and the Environment, the largest existing international network dedicated to the transformation of thinking concerning the relationship between human rights and the environment. Anna, thank you for being here.
Oh, it's an absolute pleasure. I hope my internet connection holds up. I'm getting some instability, but with any luck, you can hear me. Please sing. I want to talk about unshackling the imagination, fracking as a front line. Writing in Octavia's Brood, Walida Imaricia argues that the decolonization of the imagination is the most dangerous and subversive form there is, for it's where all other forms of decolonization are born. Once the imagination is unshackled, liberation is endless. Well, you might be wondering, what has unshackling the imagination got to do with fracking? And equally, what have decolonizations got to do with it? And my answer to that would be everything. The PPT brought human rights, climate change, and fracking together, deploying human rights as a form of vocalization of outrage and injustice against fracking and its violation of bodies and ecosystems. Fracking, as the PPT advisory opinion puts the matter, is a frontier. It's a frontier between power and oppression, and it can also be framed, I think, as a frontier between very different imaginaries of the world. PPT, a form of legality from below. It's not a formal court, but it is a forum of accountability. one that opens out different ways of thinking, speaking, naming, imagining questions of injustice, and different ways of calling for answerability. In this case, it also opens up the beginning of a much needed way of reconceptualizing human rights. Fracking as a frontier, in the words of the advisory opinion, is to be understood as a wide-scale, distributed frontier operation that divides society and nature into two parts at hundreds of thousands of separate locations worldwide. In the sacrifice zones on one side of the fracking frontier, human and non-human nature is made as cheap as possible for the use of fossil fuel economy, whose centres of power lie on the other side. Now, obviously, the fracking frontier didn't come from nowhere. It's a particularly powerful eruption of an underlying logic. This is where we need a liberation of the imagination. And it's here that we also need, I think, a reimagination of the human, of human rights. Because what fracking calls for is a new kind of ontological politics, a politics for which the very meaning of what's here is at stake. The fracking frontier ultimately feeds off a highly specific view of the world. And it's here right at the root, right in the depths of the dominant social imaginary, that the necessary unshackling of the imagination needs to take place. I want to position fracking as a distinctively Anthropocene frontier. And I want to draw a core distinction between what I call human rights of the Anthropocene and human rights for the Anthropocene. The common understanding of the Anthropocene is the idea that human activities have led to Earth system tipping points signaled by decisive markers in the geology of the planet and inaugurate the so-called new age of Anthropos, the human age. But let's pause right here to note that the Anthropos, the human, of the Anthropocene is not, despite its name, a species figuration. It's entirely clear that not all humans are responsible for conditions leading to the Anthropocene. As Malm and Hornborg argue, the processes of capitalist industrialization most commonly associated with the Anthropocene were highly uneven from the outset and entirely interwoven with European colonialism. And as European colonialism intensified over time, so Eurocentric capitalism deepened its grip, organizing the entire international legal order to serve the systematic priority of the global north over the global south. Little wonder then that the advisory opinion points directly to patterns of racism and colonialism at work all along the fracking frontier. Then a critical reading, The Assumed Human of Human Rights, has much in common with critiques of the assumed anthropos of the Anthropocene. Just like Anthropos, the human rights universal is a supposedly universal representative of the human. And much like Anthropos, the human rights universal is nowhere near as inclusive as its surface presentation implies. Human rights, as is well known, have long been haunted by important critical questions concerning the human that makes up their species category. They have been, for example, criticised for their Eurocentrism, called out for their role in legitimating an unjust international order, called out as trade-related market-friendly constructs now colonised by global corporate power, called out as key components of a new global constitutionalism for neoliberal capital, and so on. But key to these critiques and to the of human rights is the persistence of a very particular kind of human privilege. It's unsurprising then that human rights' long history is marked by struggles to include the others to its non-universal universal. So it's unsurprising that there's been the need for a kaleidoscopic list of treaties based on non-dominant subjectivities, women, children, migrant workers, indigenous peoples, and so on. And none of that proliferation has, as yet, been particularly successful in dislodging the dominant particularity of the so-called universal human, or at dislodging its underlying eco-destructive assumptions about the human as an agent that acts upon a passive nature. So if we look deeper still, we find that under these patterns, there is an ontology, a theory of what's here, of what's real, of how things are. Fracking and human rights, the Anthropocene and climate align with this ontology. It's an ontology that assumes a set of subject-object relations for which the human agent is ultimately a Eurocentric complex of rationality, agency, will, and self-ownership. Yet, work at the very cutting edge of science and philosophy now exposes these assumptions as simply implausible. Growing tides of critique also expose them as destructive, unjust, and in need of urgent replacement. And the dropping away of the traditional assumptions about human agents and objectified nature makes human rights, to say the least, rather complicated as tools of justice for the Anthropocene. Human rights in some respects are too much the human rights of the Anthropocene because they have been for too long mediated by the complex institutionalized priority of the anthropos and its implausible hierarchical ontology. But human rights are also a restless principle of hope. They're also a restless politics of the possible. They also instantiate, particularly in the hands of communities in struggle all over the planet, as was clear from what Robin shared, a powerful reaching beyond the closures of human rights themselves, a chafing against established patterns of institutionalized legal privilege, a yearning even for a planetary justice to come. If human rights are to be human rights for rather than of the Anthropocene, they need a new ontological foundation. They simply can't rest on the same ontology that brought us the Anthropocene, brought us fracking, brought us the climate crisis, brings us mass colonizing and still continues to intensify colonizing forms of hierarchy and violence. We can't continue to assume the foundations that bring all that brought it along historically in the first place. In other words, to displace the existing subject-object relations if transformation is to have a chance. And the best renewing ontological direction is a turn towards the lively self-organizing agency of materiality itself. This is in any case the only rational move. New scientific advances and technological developments are now mandating this close attention to materiality. And the findings that are emerging present, as Kuhl and Frost put it, a profound challenge to some of the most basic assumptions that have underpinned the modern world, including its normative sense of the human and its beliefs about human agency and its material practices, such as the way we labor on, exploit, and interact with nature. Science is showing us, in short, that classic subject-object relations and all the institutional and legal structures that assume them are simply out of touch with what. And if science is undermining the fundamental assumptions shoring up human exceptionalism, then the entire traditional legal, political, and philosophical grounding of human rights loses the certainty of its taken for granted. It's impossible, in the light of all this shifting insight and growing knowledge, responsibly to cling to the once comforting idea that agents are exclusively humans who possess cognitive abilities, intentionality, and freedom to make autonomous decisions, and assume the corollary presumption that humans have the right or the ability to master nature. Humans are, in reality, just one particularly problematic partner in an entangled world full of lively, pressing agencies and forces. And so in the face of this urgent need to shift, what might human rights become? First, they could become an order of rights for which the human is relocated. Now, life, its own modes of self-transformation, self-organization and directedness. This demands a whole new level of humility. Secondly, the human rights imagination needs to plunge into a world marked by entanglements and vulnerabilities, where shifting flows and lively forces co-world a vulnerable entanglement of bodies, macro bodies, micro bodies, human and non-human bodies, all caught up in toxicities and pressures. The human itself in this way is reimagined. And this is where the PPT began to step out, I think, on a potentially radical path by bringing the rights of nature into a blended jurisprudence with human rights, drawing on the imaginative and radical Declaration on Human Rights and Climate Change. The PPT in this light is just one example of a much needed openness to fresh insights, voices, traces and stories from multiple including indigenous visions of the world and important movements such as post-humanist theory and the new materialisms. Human rights could be seen then as the rights of humans as a certain kind of critter, to evoke Haraway. And this human critter is more realistically positioned in relation to the factity, the empirical actuality of human co-constitution with multiple collaborators, macroscopic, such as planetary flows and forces, and microscopic, including the microbiotic and cellular entanglements making up the human body itself. This shift would mean that human rights for the Anthropocene will also necessarily attend to the problem of radical unevenness, to the radical unevenness of material exposure to the toxicities of the Anthropocene itself, including along the fracking frontier. All the practical implications of this kind of shackling of the imagination will need working out over time. One thing to me is now certain. Without transforming ontology, without going down to the roots, there is no imaginative transformation deep enough. It is definitely time to unshackle the imagination, to decolonize our worldview, and to respond more ethically to a reimagined world as reimagined selves. Thank you.
And thank you. Extraordinary, the restless politics of the possible. Is there some place in particular where you could direct people who want to learn more about what you said?
Not really. I think that reading the Journal of Human Rights and Environment would be a good thing to do, because that's a space in which lots of people are trying to reimagine these things, bringing together respect for indigenous cosmovisions, philosophical insights from post-humanism, new materialism, and also imaginative new engagements with climate litigation and shifts within existing courts in terms of greening human rights, opening procedural practices to wider range of stakeholders and understanding the need for information and access to having a voice over environmental decision-making and things like that. There's a lot going on in that. I would also say, look at the commoning movement, look at where people are making radical on-the-ground commons-based praxis, where people are organizing in specific situated engagements with the world in which they live, new ways of relating normatively to what's there and to each other, and rethinking their relationship with their worlds, in effect. So those are some of the ideas, and read New Materialist. Thing by Donna Haraway. It's all exciting stuff.
Great, thank you. Thank you. Now the thing about an in-person meeting that is so wonderful that we don't have with a Zoom is that this is a point in any discussion when you would say, what you say absolutely fascinates me. I want to go and have a cup of coffee with you. So let's do the next best thing. And we have a half hour left, and let's divide it roughly in half. And let's, the four of us, talk a bit, shall we? And then let's invite questions from the people who are listening in. And if I might start the question, this isn't fair because it's not on the list of questions that I sent out, but it's for you, Robin. I couldn't help but think, as you were listening to Anna, that those ideas were just resonating and just ringing out and making your whole skull ring like a bell. How is this reflective of your work?
Yes, well, thank you for saying that, Kathleen, because you are absolutely right. And what I would say, I'm trying to think of how to be articulate with this, because what Anna was sharing was a profound rethinking of the way that the concept of human rights has been crafted and who crafted them. I mean, I am very mindful of the fact that the Universal Declaration was created at a time when colonization happened, and was still happening. And then colonized countries that became independent were required to join into a system that they didn't create. And that is very similar to in the United States, as we are doing the reckoning of colonization and racism that has caused us to be in this place. And what needs to happen, you know, I mean, the issue of climate forced displacement is awful. Like, I can't overemphasize how awful it is. And it also provides this opportunity for the reimagining of how we create human community in connection with the earth. And I don't think that that has been even embarked on in regard to this revisioning of our world that honors our humans and our human connection with the earth and all that sustains all of the species on this planet. And that is the work that needs to be done, is to reimagine what human settlements will look like in a dramatically climate altered world, and one that is not like end of century, right? But within the next 10 years. I mean, right, with what I just shared about what's happening in the Arctic, this reimagining needs to be happening now and then implemented.
Anna and Tom, did you want to respond to that?
Anna?
Look, not trying to force it, but Tom, the question I was going to address to you is already in some parts answered, because what Robin is pointing out is that we're maybe asking is, where does this reimagining begin? Where does it take place? How can we push it forward? And it seems as though the Permanent Peoples Tribunal was beginning some of that reimagining. So let me ask a broader question. You know, when you take a case to an international human rights court, what difference does it actually make? How can it actually change the world?
Oh, I'm going to answer that with words that you've used, Kathy. It makes a difference. You said in an article that you wrote about the tribunal when we were first getting organized, it makes a difference to tell the truth. And it makes a difference to lay out what norms should be applicable. It makes a difference to tell the truth. I just, that really resonates with me. And I mean, every time I hear you lay out these issues, I'm just sort of flabbergasted. One of the ways that I think personally, trivially, try to rethink the rights system is imagining, you know, we humans have courts. We set up standards about what's right and wrong, and we have courts for adjudicating those standards. What about if dogs had courts too? You know, they would have a different set of expectations, a different set of norms, but and if they brought us to their courts, for example, we might not fare so well. What about if the forest, as we're beginning to see around the world now, river systems, what about if they had rights and courts? what would they think of the way humans have been behaving for the last many centuries? So when I try to step into a dog's head, when I try to step into the river system's way of being, it helps me try to imagine what this new imaginary might look like.
Well, let's give that question to you, Anna. There are, as you can tell us, lots and lots of places around the world where there are new statutes and constitutions that give rights to natural objects, natural beings. Is that the right way to proceed? Is it going to be rights and courts that are going to make this transition, or is that just perpetuating the same ways of thinking?
I think it does both. I think it's an ambivalent tool, and there's some evidence that shows even where you've got rights of Mother Nature in a constitutional settlement, that neoliberalism just runs on as usual, and mining and extractive priorities still continue to unfold. So they're not an inherent answer, but what they are is a tool. They're a language and a way of bringing claims into the juridical system, making political and legal arguments that have resonance. But I suppose my hesitation is always that the legal system itself is so entrenched in particular sets of hierarchical assumptions, and so entrenched in the system as it exists, that it's always going to be somewhat compromised. It's always a relief when you find a radical judgment that breaks out of it. But until we actually break some of the elite, organized, historically embedded patterns of unevenness and injustice that actually feed through the legal system and in a sense are also legitimized by the legal system. And this is a problem with questions of environmental justice. Environmental zoning laws are often used to legitimize racist distributions of zoning sites into communities of color. When you actually strip back the layers of so-called neutrality, objectivity, and legality, you often find that what you find is these patterns that are actually depressingly predictable, deeply predictable, and deeply familiar distributions of risk, familiar distributions of life and death. So rights-based thinking is both intrinsically limited, but also a potential tool. And I think as long as we use it in a way where we understand its limitations and we understand its intrinsic baggage that it comes with, and we can think about using them subversively, more decolonially, perhaps that's a useful thing. But I don't think we're ever going to arrive at justice. I think that whole idea is radically mistaken, and I think the most we can do is continue to spot and resist injustice, because for every settlement we make, for every point where we arrive at some solution, we will find excluded communities, we will find new forms of closure and different patterns of unseen suffering that needs to be made visible. And I'm convinced that will always be the case. I mean, Donna Haraway writes beautifully about staying with the trouble we're in, And the task then becomes intelligent. How do we work intelligently, compassionately, with guided by radical passion for justice, love, and inclusion in these very struggles in which humans and non-humans now are irrevocably caught up together? Rights, I think, is one tool in that, but a limited one, in my view, in my current thinking.
Mm-hmm, mm-hmm. And maybe in a crisis that is this extraordinarily severe, all the tools that we have at our disposal should be brought to bear. But as you say, with some awareness of what they carry with them. So Megan, we are coming to the time when we would welcome questions from the people who are listening.
Hi, everyone. Yeah, by all means, please drop any questions you have in the chat. The chat is on the right-hand side of the YouTube video.
I have a question for Robin and Anna about other models of justice seeking. particularly in indigenous communities? What other models can we turn to? Where can we learn about them for dealing with conflicts and big decision-making questions? Where would we go to learn more about those other potential systems?
I don't know if I could answer that, Tom, honestly. I mean, it's not the area of the focus of my work with the indigenous communities that I've worked with. And I would also share that we, in the United States, the colonial systems of how indigenous tribes get federal recognition, and then the methodology that's used to provide funding for quote unquote tribal courts and tribal governments. I mean, and I could be wrong about this, but that's all been created by a colonized system, right? It's being imposed on tribes as opposed to tribes saying their truth now of what that would look like. And I think there are mechanisms that are being created to identify that as a way of seeking accountability. I mean, I would say, and I will just speak for Alaska, there has not yet been the accountability that is, in my mind, required to understand what colonization has done and is doing to tribal communities.
Anna? Okay. Megan, are there questions coming in?
Again, I can't claim to be an expert on. Okay.
I do not see any questions right now. Of course, because of the YouTube stream, we are on a 30-second lag, so maybe some will come in the future. But I have a general question for all of you all. So we talked a lot about what the legal community can do to address these issues. What about people in the audience who are just like from the general public? How can they get involved, or what everyday actions can they do to help address these problems?
Well, in the answer to that, I would ask Tom to share with us his idea for youth climate courts, because this is a way of empowering young people to do the same sort of truth telling in a way that commands attention. Tom?
Yeah, thank you. The idea of youth climate courts is a way of empowering young people to just take a group of young people, I imagine high school or college or up into their middle 20s, just declaring themselves to be a youth climate court. And then they decide to put on trial their local government, their city or their county, for failure to protect their citizens' rights vis-a-vis the climate crisis. So it is. There's been one conducted already in Australia and one being organized here in Oregon, in which here in Oregon, it's 8 or 9 high school girls who are putting their local city on trial for its failures to protect them vis-a-vis the climate. And they'll conduct this trial on a certain day in the spring and invite the city to come and defend itself. And the prosecution is in this case is a team of two team members who will argue that the city's not doing its job human rights wise. And then if the city is found guilty by a youth jury, then the court issues mandates to that city saying you have to declare climate emergency right away. No more hesitation. You have to develop a science-based and human rights respecting comprehensive climate action plan and get it done by such and such a date and send it back to us, the court, for our approval. If we don't approve of it, we'll send it back to you. And then the youth climate court keeps the pressure on during that whole process to make sure that the government follows through on its mandates. So this is a sort of a newly creative kind of model, but it is based on the court system. And I've talked to some folks, law profs and law students in Canada who like the idea, but have raised all those issues that Anna, you, and Robin have both raised about colonization and why would we trust courts, the whole indigenous communities, why would we trust courts that have treated us so badly? So maybe we need another model. And the only other models I think of is a Truth and Reconciliation Commission model, which they've done in Canada with Indigenous peoples a few years ago. I don't know what the outcomes have been. And another is a restorative justice model. But so the reason, I mean, I'll ask again, is it worthwhile looking elsewhere, particularly among Indigenous communities, for other models of justice seeking? Because we're so stuck in this framework, you know, the contentious judge, jury, etc. Is that a worthwhile endeavor to go looking for other models, do you think?
Definitely, I would say definitely. And also I think it's important to see the value of legal pluralism and the fact that, you know, you can have multiple different kinds of systemic approaches that are sort of marginalized by the mainstream thing. But I think a really key thing is this grassroots level energy that different communities bring to concerns. I think that's hugely important because some of the kind of proposals I'm hearing are very Promethean. The idea that you have this big oversight, global level oversight that brings everything together. To me, that's just a recipe for continued exclusion, control, and reproductions of unevenness. I think we have to take a cue from complexity science, from insights into how materiality works, and start thinking in terms of distributed intelligence and emergence, a set of emergent practices that don't have to be the same and don't have to be aligned and don't even have to be harmonious, but just are located where they are, doing what they can. In other words, I think we need to throw away quite a lot of our assumptions about what it means to do law. And we need to really diversify and think in a far broader framework of different kinds of normativities. And that's why I think the commoning movement is so exciting. I also think it's very exciting to see youth protest movements. I think it's very exciting to see youth protest movements turning to creative climate litigation. I love the idea of your alternate courts. I love the idea of courts that don't sit within the system, because these are all ways of raising consciousness, of engaging, but actually until the system changes, until we actually break the power, the sociopathic power that is currently exercised at the international and national level by neoliberal structures, then we're not going to get that far unless a lot of people right on where they are wake up. And actually one of the things that really inspires me about the climate change issue is that the information action ratio is very intimate. It matters what I do in my day-to-day choices in relation to climate change in almost a way that I can't imagine it mattering in respect of other things in quite the same way. It matters what food I eat, what toxins I put into the local environment through my body as a toxic source or a source of clean, nutritious exchange with the local environment. It matters what I do about my consumer patterns. It matters how I vote in order to change the structural commitments of the parties in the nation where I live, and so on and so forth. There are so many multi-layered, multi-leveled aspects to this, and I think individuals can get involved at lots of different levels in multiple ways, but this is an issue that really comes right home. And one of the things I think it does more than anything else is it challenges us to evolve our consciousness. And actually one of the most vital contributions we can make to the seeking of justice is to actually evolve as someone who feels like a planetary being, who's connected, who's concerned for the collective, who's compassionate, open, non-reactive, unthreatened by difference, able to embrace and love otherness, and actually just to grow the heck up.
Well, and if I could follow on what Anna was saying about the what we can do as individuals, I think we really need to be paying attention to what's happening climatically in the places where we live, because they are in the process of changing dramatically. And if we want to be the ones, we being people living in communities, to decide how we are going to adapt, we need to be really paying attention to the environmental changes that are happening, and then visioning the adaptation that we want, so that we are not responding to decisions being made by governing authorities that have different priorities than the ones that we have. And I would say that is urgent based on the severity and of acceleration in regard to the climate crisis, because as I said, this issue of climate forced population displacement may be happening to very few communities right now, but that is absolutely going to change, and it's going to change very soon, meaning within this decade, we are going to see accelerated population displacement because of the climate crisis, with no solutions being conceived of right now that are based in the rights of humans and the rights of nature, and ensuring that there's just and equitable solutions.
Thank you so much, all of you. Megan, will this be recorded and available in some other way?
Yes, it's recorded and it's going to be posted to the PILC YouTube channel. Just simply Google PILC, PIELC, into the YouTube bar, and then it'll pop up. But thank you all for attending this panel. I'm going to drop another link in the chat, which this link is to our brochure for the rest of the scheduled events we have today, tomorrow, and Sunday. Kathleen, do you have any parting words before we log off?
Only words of gratitude and absolute inspiration at the way that we might decolonize our imagination, unshackle our imagination, and move forward. And when anyone ever asks me, what can one person do? My answer always is, stop being one person. There's extraordinary, exciting things happening all over the place, and find your choir, join your choir, and you will find your role. And thank you particularly to the law students at the University of Oregon for putting this all together. This is a great gift to us all.
Yes.
Thank you. We appreciate the kind words. Okay, with that, I think I'm going to end this YouTube stream.